Hey y'all, how are y'all doing this morning, afternoon, or night based on wherever and whenever you're tuning into this video? I hope you're having a wonderful day today on this October 31st, 2024. Guys, can you believe it? Tomorrow will be November. Why am I so excited about November? Well, my birthday's in November. So once we start on November 1st, the countdown begins. My birthday is November 19th. So I'm excited about it. I have some exciting plans for my birthday, and I will be sharing some of them with you guys, some of my plans. So, let's see. Today, actually, this was filed yesterday, probably late last night. I don't know. The government and, well, I guess the PACER system updates and archives these documents once they come in electronically. So the federal government has responded to all of the motions made on behalf of Sean P. Diddy Combs. One of those motions was for the federal government to release the names of victims / witnesses. The other motion was, I think, a request for a gag order, gagging not just the folks in the courtroom, the prosecution and the defense, but extending it also to civil litigants, meaning the Tony Busbys of the world, who are going after the billionaire mogul civilly. So that motion, let's see. Let me make sure. Oh, and also their claims that the federal government has been leaking information. Now, this is going to be a lot of reading, guys. And for those of you who do not know, I have hold on a second, guys. One moment. Okay. I have centric eye nerve damage in my eyes. So that's why I will pause, or that's why my pace is a bit slow while reading. So just bear with me. Let's see here. All right, let's get into it. So this is the government's response. This is the preliminary statement from the government. The government respectfully submits its response to the series of motions filed by defendant Sean Combs since he was indicted by a grand jury sitting in this district a little more than a month ago. His motion for evidentiary hearing, among other relief, in response to purported leaks at docket number 30, the leak motion. His motion to require the government to identify victims, and they identify where it is on the docket number 36, the bill of particulars motion, and his motion for an order prohibiting extrajudicial statements from civil litigants, the victim gag motion. First, the court should deny the leak motion for the simple reason that the defendant fails to show the leak of any grand jury material. Without any factual basis, the leak motion seeks to suppress highly probative evidence, a video of Combs brutally physically assaulting a victim in March 2016 that was published by a media outlet on May 2024 by claiming that it was grand jury material leaked by the government, by government agents to CNN. But as the defendant is fully aware, the video was not in the government's possession at the time of CNN's publication, and the government has never at any point obtained the video through the grand jury process. The defendant also complains. Yeah, why the feds, why they wrote it like that? He also complains about purported law enforcement sources leaking other alleged grand jury material to the media in several news articles cited in his papers and set forth in the attached table of contents. Cited articles. Here, too, the defendant is grasping at straws because the defendant cannot show the information in the cited articles is grand jury material, and because he cannot show that the government agents with access to grand jury material leaked the information, he cannot make a prima facie showing required for the relief he seeks. Moreover, even if any of the information in the cited articles could be considered non-public information, improperly disclosed, the defendant's request for relief under Local Criminal Rule 23.1 is moot by the order entered by this court on October 25th, 2025. Now, for those of you who do not know, Judge Subramanian, he put in an order, a gag order, essentially. The order states that neither party or any other individual who is associated and or involved with the case is allowed to oh my gosh. My bad. Hold on, y'all. I just lost my train of thought. Oh, dang, allowed to speak on the case. Sheesh, it's too early for me, I guess. I don't know. But the judge put in an order. The judge rejected both sides' rendition of a gag order and imposed his own. So the request for the gag order and gagging people like Tony Busby and his clients, that's a no-go. Now, second, the court should reject the defendant's bill of particulars motion as not only unnecessary but improper. As an initial matter, the defendant has been more than sufficiently apprised of the charges he faces, including through a 14-page speaking indictment. The government's submissions and statements on the record in connection with the defendant's bail, hearings, and sufficient productions of discovery, and at the appropriate times in accordance with the well-established practices in this circuit, the defendant will receive even more disclosures about the conduct with which he is charged, including through additional discovery, an enterprise letter, a witness and exhibit list, and John, I think it's Junk Jex. It's JENCKS, JANOX Act material. I looked that up, and the definition for JANOX Act material, the JANOX Act, also known as 18 USC 3500, is a law that requires the government to disclose statements made by its witnesses to the defense after the witness has testified on direct examination. So that part that they're referring to, that he'll get more information through this particular act, they're basically saying that he'll get it at trial. Okay? Accordingly, the defendant cannot credibly claim that he will suffer unfair surprise. He will suffer unfair surprise at trial. Rather, it is plain request for a bill of particulars containing victims' names is merely a vehicle to attempt to prematurely restrict the government's proof at trial and use these criminal proceedings to defend himself in the press against complainants in separate civil litigation. This improper request should be denied in its entirety, particularly here, where there are serious and ongoing concerns of victim and witness safety, tampering, and intimidation. Finally, the victim gag motion should be denied as an attempt to backdoor the federal rules of criminal procedure to compel the government to prematurely disclose its witness list. Indeed, by seeking a preemptive gag order under Local Criminal Rule 23.1, preventing potential witnesses in the criminal case and their counsel from making extrajudicial statements. The defendant is essentially asking for either a blanket order that would apply indiscriminately to any individuals with claims against Combs and their lawyers, or for a more limited order that would require the government to identify its witnesses 6 months before trial. Not only would such relief be unprecedented, but the defendant should not be permitted to use a local criminal rule as a sword to gag civil claimants, whether or not their statements were connected to the proceeding, or to evade established case law in this circuit. So there the government is kind of teetering, saying that, hey, maybe some of the civil clients are our witnesses and we don't want to say right now. Basically, that's what I gleaned from that. What do you guys think? Y'all can answer on the replay if you're not here in the room right now, but what do you think based on what I just read? It sounds like what the government is stating is that if they were to narrow down the list, they would have to release the names of people that they're already potentially talking to. That's what I'm picking up from it. Now, the procedural history. In or around November 2023, and as described in more detail below, federal prosecutors from the United States Attorney's Office for the Southern District of New York, working with case agents from the Human Trafficking Squad of New York Field Office of Homeland Security Investigations, began investigating Combs and others for violations of federal criminal law. Now, I want to know who the others are. And I'm just waiting on this superseding indictment like I'm waiting on Christmas. I made a prediction that the superseding indictment was gonna come out before November 19th. And I strongly believe that the superseding indictment is coming down the pipe. And I'll be on the lookout for that and keep you guys updated. Now, on September 12th, 2024, a grand jury returned a 3-count indictment charging the defendant with racketeering, conspiracy, and violation of 18 U.S.C. 1962D, count 1, XXX, trafficking by force, fraud, and coercion in violation of 18 U.S.C. 1591A, 1B, 1594A, and count transportation to engage in Lady of the Night positions in violation of 18 USC 2421A. as alleged in as alleged in detail in the indictment, in the 14-page speaking indictment, starting in at least 2008, the defendant participated with others in a racketeering conspiracy that he led and controlled, the Combs enterprise. The defendant and other members and associates of Combs's enterprise wielded the defendant's power and prestige in the entertainment industry to cause female victims to engage in extended XXX acts with male commercial XXX workers, referred to as freak-offs, which the defendant directed, masturbated to, and often electronically recorded. The Combs enterprise accomplished its goals through acts of violence and obstruction. With respect to the freak-offs, the defendant threatened the victims with the electronic recordings of the XXX acts as collateral. Okay, so they are saying that he was blackmailing folk. So he was blackmailing people. Okay. In addition, the defendant physically assaulted women and others by striking, punching, dragging, throwing objects at, and kicking them. Members and associates of the Combs enterprise also at times carried pum-pums, and on more than one occasion, the defendant himself carried or brandished pum-pums to intimidate and threaten victims and witnesses of his crimes. Further, when the defendant's power was threatened, the Combs enterprise engaged in acts of violence, including kidnapping and arson, and pressured witnesses and victims, including through attempted bribery, to stay silent and not report what they experienced or knew to law enforcement on phone calls. The defendant and other members and associates of the Combs enterprise, among other things, provided these victims and witnesses with a false narrative of the events in an effort to conceal the defendant's crimes. Following the return of the indictment by the grand jury, Combs was arrested on September 16, 2024. The next day, on September 17th, United States Magistrate Judge Robaline Tornitsky ordered the defendant detained pending trial. United States District Judge Andrew Carter, to whom the case was then assigned, held another bail hearing on September 18th, 2024, after which he ordered the defendant remain detained pending trial. In reaching his determination, Judge Carter stated that the defendant is a danger regarding obstruction of justice and witness tampering, and a danger to the safety of others in the community more generally. In the last month, the defendant has filed multiple applications for relief from the court, each one insisting that the relief sought was necessary and urgent. On October 9, 2024, the defendant filed the leak motion seeking various forms of relief, including an evidentiary hearing, discovery, a gag order, and suppression of evidence. The defendant filed a bill of particulars motion pursuant to Federal Rule of Criminal Procedure 7F, asking the court to require the government to identify the victims in the case more than 6 months before trial. Finally, on October 20th, the defendant filed the victim's gag motion related to media statements from civil plaintiffs and their attorneys, seeking an order prohibiting prospective witnesses and their counsel from making extrajudicial statements, among other relief. The investigation of the defendant. Together with case agents from HSI New York, federal prosecutors from the Southern District of New York commenced their investigation into the defendant and others in November 2023. That is right around when that's actually the exact month that Cassie filed her case. As part of that doesn't say that in this document. I'm saying that, guys. November 2023 is when Cassie filed her lawsuit. Okay. Now, as a part of the investigation and pursuant to the authority of the grand jury issued subpoenas to obtain evidence, including documents and other records, as well as witness testimony. To date, the grand jury has issued over 300 subpoenas, and the government has interviewed over 50 witnesses, several of whom testified before the grand jury on September 17th, 2024. The government also took other investigative steps outside of the grand jury process, including obtaining a multitude of judicially authorized search warrants for, among other things, searches of cloud storage accounts. The government governed by and the Stored Communications Act, 18 U.S.C. 2701, and searches of certain premises, persons, and electronic devices in accordance with Rule 41 of the Federal Rules of Criminal Procedure. 1. Grand jury materials. The grand jury investigation of the defendant proceeded in accordance with Rule 6 of the Federal Rules of Criminal Procedure, which governs, among other things, secrecy of matters, agents, task force officers, and press officers who have or currently work on the case as senior HSI leadership. Before the grand jury and materials considered by the grand jury. For the purposes of this motion, the government attorneys, analysts, and law enforcement agents who have access to Rule 6 materials are referred herein as prosecution team. Okay. Throughout the investigation and in accordance with Rule 6, the grand jury issued subpoenas for various records relevant to the investigation, including inter alia hotel records, travel records, financial records, and phone records. The records returned in response to these subpoenas were maintained pursuant to Rule 6 at both HSI-NY and the USAO, the U.S. Attorney's Office of the Southern District. Access to the repository of electronic files containing grand jury information is restricted to the prosecution team. Specifically, at HSI-NY, the only 3 assigned HSI agents can access all of the grand jury material, and if an unauthorized individual attempted to query or access the case file would appear to be empty to the unauthorized agent. So basically, right there, they're clearly stating that not everybody has access throughout the federal government to the grand jury materials. So all the leak and all this conversation that the defense is trying to put out there, that this is not going to be a fair trial, that, there's leaks coming out of the government is pushing back on that claim, because there's only 3 Homeland Security agents with access, and only the prosecution team, people who are directly related to the case, the prosecution of this case is allowed access to this information. In addition to the lead case agent would receive a notification of the identity of the unauthorized agent who attempted to access the case file. March 25th, 2024 search warrants. Now, we know the search warrants that they served on his home, simultaneously in California and in LA. Not why did I say California, LA? California and Miami, Florida. It's too early for me, y'all. It's too early. I'm not this early of a person, but I wanted to get up here early to get this update to you guys. I hope you guys are doing well. Be sure to hit the like button if you're in here listening to me go over this information. Now, discovery. Since the defendant's arrest a little over a month ago, the government has made 3 significant production of discovery material, which includes the following categories of materials: all search warrants and supporting affidavits, hotel, financial, and communication records produced pursuant to grand jury subpoenas, and electronically stored information from over 60 of the defendant's own devices and iCloud accounts, including, among other things, text messages, audio and video recordings, photographs, and documents which the defendant had requested be prioritized. These materials contain additional details about the allegations against the defendant, including, for example, specific allegations related to multiple victims in search warrant affidavits and communications with victims and witnesses from the defendant's devices. Forthcoming discovery will summarily contain additional details about the alleged conduct, including additional communications with victims and witnesses, travel and hotel records relating to freak-offs, bank records showing payments to victims by the defendant and entities associated with the defendant, and police and fire department records relating to the kidnapping and the arson discussed in the indictment. Now, here's the government's argument. Okay. Under the law in this circuit, all 3 of the defendant's motions should be denied in their entirety. First, with respect to the leak motion, the defendant has not made a prima facie. This is the same thing that they said before. I'm not reading that again. So basically, the government intends to completely ignore Diddy and his attorney's request for the victim gag order, for the additional information. I'm scrolling, y'all, so I can see what this is. Let's see. Okay, so there's an email here. It says, "Good morning, all. I'm sorry to bother you with this, but we received word that CNN has been given a video." This is an email dated May 17th, 2024, and it's from his attorney to the government. Intercontinental Hotel, blah, blah, blah. They're saying that they they feel like the, I guess, CNN video. I'm trying to make sense out of this. What is this? Oh, these are the items that they sent over to Exhibit C. Okay, to be clear and understanding, DHS didn't have the CNN video, so. Okay. There's nothing, they're really keeping it close to the vest as far as information, but they would like the judge to reject all of Diddy's motions and allow them, I guess, room and space to be able to properly prepare for this prosecution. And they've said basically that everything that they have disclosed to him is more than enough for him to mount a defense. Even with the 14-page speaking indictment, that should be more than sufficient. That is what the government is stating. So we shall see what happens. Like I said, I believe there will be a superseding indictment coming down the pike soon. I don't know that they're going to name additional people in the indictment, but I do believe that there will be additional charges. I feel strongly that there will be additional charges, and that's just how I feel in general. I don't know why I feel like that, but I do. I also feel that his trial date that's set for May 5th, 2025, I don't think that's going to happen. Now, I don't know if his attorneys are very good. He has a great team of attorneys that he's hired on, but I don't know that they will be able to prepare once the suit, prepare. They technically, let's see, they have November, December, January, February, March, April, May. They have 7 months to prepare. Well, technically 6 months to prepare for this trial. Once the superseding indictment comes down, if it does, as I feel, that's just how, I don't know why I feel like this. I feel like it's going to come before the 19th of November. I feel that they're going to go ahead and slide that out. Yeah, I believe they're going to slide that out. If not before the 19th, it'll definitely be before Thanksgiving. We'll see. Guys, I will keep you posted. Anything else happening in relation to the United States versus Sean Puff Daddy Combs, I'll be back on here.